the provision by the Chamber in the previous decision does not give effect to the plain language of the article. Indeed, if the article had started in line 2 with the words official capacity as heads of state and read from there on, that then would have been, in terms, a provision which simply provided that heads of state enjoyed no immunity from prosecution. However, to say that that is all the provision does ignores, in our respectful submission, what precedes those words. And that is the following. The first sentence says, "This statute shall apply equally to all persons without any distinction based on official capacity." And the first two words of the next sentence, the link words which we submit, are particularly significant. In particular, official capacity, etc., etc. The prosecution therefore submits that the prohibition of immunity based on official capacity is one particular example which the legislators have selected for emphasis of a wider category or a wider principle which is captured by the first sentence. In other words, equal application under the law. And this, again, we submit is consistent with the interpretation which is required by Article 21.3, which mitigates against or militates against distinction based on status such as official capacity. And further, Your Honours, we submit that is consistent with the underlying general principle of law, of equality before the law, and indeed one of the very building blocks and raison d'etre for this court, and that is the end of impunity, including impunity for persons holding high official office. Furthermore, we submit that this interpretation is supported by a contextual interpretation of the provision. If one looks at the architecture of the statute, one will see that Part 2 deals with inter alia jurisdiction of the court. Article 19 deals with grounds for objection to jurisdiction of the court by an accused in a particular case. And if Article 27.1 had been intended to be limited only to removing a ground of objection to jurisdiction, one would have expected such a provision to have been included in Part 2, in particular in Article 19. Instead, the legislators have chosen to include it in Part 3, dealing with general principles of criminal law, which, in my respectful submission, supports the prosecution's argument that this is intended to be a more general application, a rule of more general application and general principle.
But doesn't the same concern worry your own submissions about if all that 27.1 does is what it says from the second sentence? One can flip that to say, is it the case that all that 27.1 does is what's indicated in the first sentence?
That is not the prosecution's position with respect, Your Honours. We submit that the first sentence is the broad principle. There should be no distinction before this court in the application of the statute, and that's the whole of the statute, based on official capacity. In particular, the application of Part 2 dealing with jurisdiction and Article 19, there shall be no distinction based on official capacity. So it's a specific subcategory of what we submit is the wider principle of law captured by Article 27.1.
You also said that, correctly said that provisions are to be, statutory provisions are to be interpreted in context. That is what I mean by correctly. Does not, isn't the case that context will necessarily begin with the immediate textual neighborhood of the provision itself? Isn't it the case? You're not.
Yes, that would be one of the factors to be taken into account, and I presume Your Honour is referring to Article 26.
No, you presume wrong.
Oh.
I talk now about the immediate neighborhood of 27(1) itself. The first sentence is necessarily situated in the context of both the second sentence of 27(1) itself as well as 27(2). And if we look at that, if you can look at it, first sentence, this statute shall apply equally to all persons without any distinction based on official capacity. It doesn't stop there, and it continues, and this is what I mean by the immediate neighborhood of the context. Continues, quote, in particular, official capacity as a head of state or government or a member of a government or parliament, an elected representative, or a government official shall in no case, the official capacity that is, exempt a person from criminal responsibility under this statute, nor shall it in and of itself constitute a ground for reduction of sentence. Rather, there is the indication, isn't it, that the mischief is exemption from criminal responsibility. So that's one context. The other context, and then after I'm done, you can give me what you say of it. The second context applies again, comes in directly in 27(2). 27(2) says immunities or special procedural rules, and we'll talk about that later, which may attach to the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over a person. Again, the context there, does it not suggest that the mischief of 27(2) is that you may enjoy certain immunities, you may enjoy special procedural rules or privileges from special procedural rules, as long as you're not exempt from the jurisdiction of the court. Isn't it what it says?
That is what it says, Your Honour, but as to the interpretation and as to the contextual interpretation, starting with sub-article 1, the way in which sub-article 1 is drafted runs, in our submission, from the general to the specific. The question which the court must determine is whether the one qualifies the other, and if so, which qualifies which. The answer in our submission is to be found in the linkage between the two sentences. In particular, the words "in particular." So the prosecution submission is that the way the sub-article is drafted is the statement of a general principle of law, and that the legislatures then selected for particular emphasis one subcomponent of that general rule, which the draft of the statute rightly selected for special attention as being particularly important.
Could it be what's going on, or could it be making it abundantly clear that pre-existing understanding of international law or as exempting certain people from criminal jurisdiction does not apply? I recall, for instance, was it Vattel who said that the dignity of the prince makes it imperative that he not be subjected to the ordinary statutory, penal sanctions that ordinary citizens may endure. that was the understanding when Vattel wrote his book. And up until the Second World War, that seemed to be the understanding. Could it be that what the second sentence of 27.1 is doing is making clear, leaving no doubt at all, that that rule no longer or does not apply at the ICC?
Your Honour, the prosecution makes no argument with that. We think that that is indeed what the second sentence does, but that the second sentence cannot be read in isolation. One cannot think away the first sentence and the connection between the two. And if any interpretation of Article 27.1 in our respectful submission, which has the effect that that is the only object of 27.1, does not give due weight to the first sentence and the general principle which has been enunciated in the first sentence. In effect, it simply thinks that first sentence away.
What about 27.2? What does it tell us? Does it have any role to play in this matter?
In the first instance, apart from the general context, there is no qualification under 27.1 along the lines of subject to subrule 2. So the one is not subjected to the other. And I don't think the presence of, my submission is that the presence of subrule 2 should not change the plain meaning of subrule 1.
But it should begin to tell us whether or not there is any inconsistency between 134, Rule 134 quarter and Article 27.1 itself, doesn't it?
The Court will bear with me for one moment, please.
And I'm looking at 27.2 itself. It does say, recognize that special procedural rules may apply, as long as it does not exempt anyone from the jurisdiction of the court. Isn't it the case that what 134 quarter does is provide special procedural rules? Isn't it the case?
In my submission, this provision is referring to immunities or special procedural rules applicable to certain persons either in their domestic jurisdiction or in international law as it existed prior to this.
It doesn't say prior to. It says whether under national or international law, and we are now in the realms of international law, so it is 134 quarter.
Again, this is a specific provision which bars any such provisions from removing jurisdiction or providing immunity. What it does not do, in our respectful submission, is derogate from the general principle which is enunciated in Article 27.1, that the statute applies equally to all persons regardless of official capacity.
But is it possible to justify... Now, let's for instance, forget about, for purposes of the discussion we're going to have now, 27.1. Let's say that all we are contending with is 27.2. Would you say that there is an inconsistency between 134 quarter and 27.2?
Your Honour, I would say not, because they deal with different subject matters. And 27.2 is specifically confined to the issue of immunities and special procedures and the question of jurisdiction in terms. There is no general provision or general principle contained there other than that. And to the extent that Rule 134 does not deal with jurisdiction at all or immunity, the two do not overlap and the one does not impinge upon the other. We submit, however, that 27.1 has a wider meaning which is infringed upon by and let me emphasize, not by Rule 134 quater, but rather by the interpretation of 134 quater advanced by the defense.
One more line of questions for you. Again, so I can get a bearing on this thing, better bearing. Official capacity, that's what 27 deals with. Official capacity. 134 quarter, it speaks of extraordinary public duties. Do they mean the same thing?
Your Honours, no. Not in our submission. Not properly interpreted, no. Unfortunately, the definition advanced by the defence conflates the two concepts, in that the defence's argument is that by virtue of Mr. Ruto's position as the Deputy Head of State of Kenya, all of his duties are necessarily of an extraordinary nature, which is no more than to say that it's, let me phrase it this way, the mere occupation of that office on their argument will automatically lead to the excusal of an accused. And what is that other than excusing the accused on the basis of his official capacity?
Yeah, the one thing that we need to consider, though, is that there are some official capacities that are merely official capacity in the terms of 27.1, that one may say are merely ceremonial.
Yes.
Official capacities now, not functions, because 27.1 talks about official capacity. Official capacity may be merely ceremonial or sinecure position, titular posts, honorific ones that call for little or no work, sort of thing. But then one may say, well, immunity attaches to the official capacity, notwithstanding that I'm occupying the official capacity, doing no work, I must still be recognized. That's a separate matter from, isn't it, from executive president or executive vice president who actually does real work in governing a country. Isn't that the case?
Yes, Your Honour, there certainly is a distinction there, which is not to say that every official act done by a deputy president will necessarily be extraordinary. There is mundane work in even the most important person's calendar. We give the example of opening a road or addressing the opening of Parliament. That may fall more into the realm of ceremonial, I suppose. But the prosecution submission is that what is required by Rule 134 Quater, properly interpreted, is for the defence to make out the case in their request that what the duties which the accused, in this case Mr. Ruto, will perform instead of coming to court are extraordinary. It is not sufficient to say, because he is an important person, because he is elected as the Deputy President, therefore everything he does is important. And I would note that unlike the, and this point is made very clearly in the Common Legal Representative submissions, and we endorse this point, that the duties of the Deputy President are not actually defined in the, or put it this way, are not clearly defined in the Kenyan Constitution. It's basically his duties are to do whatever the President mandates him to do, which may be anything from the extremely important to the extremely mundane. One simply doesn't know. So one cannot simply hold up the Constitution and say, look at the important things that my client is mandated to do, and that's enough. There must be more. What we are simply saying is that the defense must make out their case before we can be, that the prosecution can be expected to meet it. Your Honours, there's only one more point that I would make, and I wouldn't have made it except for the unfortunate position of the Common Legal Representative in having filed his responses out of time, which I must confess I hadn't noticed. But apart from the argument about the functions of the Deputy President, we also endorse the views of the Common Legal Representative as to the interpretation of what is meant by the highest national or at the highest national level.
We cannot see what you're endorsing.
Yes. Well, let me spell it out then. The point I intend to make, and I'm sure Mr. Oshlan will flesh this out, is that by the use of the superlative adjective highest, the prosecution, it seems to the prosecution that the intention of the ASP was to limit the application of 134 to the apex of government. If this is not to be the interpretation, this begs the question, well, where does the highest national level end? Does it end with the President? Does it end with the Deputy President? Does it end with the Secretary of Cabinet, the Ministers, Parliament? What about the head of the army or the head of the police, who perform the highest executive functions in those areas? And we endorse the argument that 134 quater will only apply to Mr. Ruto if and when he is substituting, deputizing for the President in his absence, or alternatively has been delegated one of the functions of the President by the President. And it's only in the realm of those duties, provided they are exceptional duties, that 134 quater will apply.
So I understand you, Mr. Steinbach. Your argument is that being the executive deputy head of state of the country does not qualify as occupying the highest national, operating at the highest national level in the public life of that country. Is that your argument?
Your Honours, my answer is this. The highest level of national government is the President. The Deputy President is the second highest. And I can take it no further than that. Unless there are any further questions from Your Honours, we rest on our written submissions.
Thank you. Mr. Nderitu? Sorry. He's not here. You mentioned him, so Mr. Narasimhan, please.
Good afternoon, Mr. President, Your Honours. I'm aware of your clear instructions, and I'm also aware of the fact that we are operating under time constraint, but I'm afraid that I have to make a request. Our request is this, Your Honour. I must admit that when you indicated that our submission had been filed out of time, we actually were under the impression that our filing was filed in time. But, as you have indicated, we have gone through our records then, and we do now realize that we indeed missed the time frame set by the Chamber. But, our request is that you would extend the time frame retrospectively, under Regulation 35(2), since we have a good cause to show, and we have exceptional circumstances that we need to explain to you, Honours. And also in the jurisprudence of our court, there were circumstances where chambers had granted retrospectively extension of time limits. First of all, Your Honours, Mr. Nderitu, when he filed his submission on 9th of January, he did so in good faith. He mistakenly but innocently believed that the reasons that you have granted the prosecution's request in your decision extending the time limit, he, in good faith, believed that those reasons would equally apply to his team as well, since we have all been back to our Christmas break. Of course, just as...
Just let me stop you now for a minute. When you mentioned Regulation 35(2),
yes, Your Honor.
And you also indicated the word retrospectively, does Regulation 35(2) say the Chamber may extend time retrospectively?
It doesn't explicitly say that, Your Honor, but in the practice of the court, I clearly remember the cases where chambers have done so, Your Honor. And, Your Honor, accepting Mr. Nderitu's written submission would not cause any prejudice to any parties in participating in these proceedings, Your Honor. As Mr. Steinberg for the prosecution, also Mr. Khan for the defense, they have already made reference to our written submission, and there wouldn't be any surprise effect. They had time to familiarize themselves with our written submission, and they have replied as well, Your Honor. And rejecting our written submission at this moment, Your Honors, would be detrimental to the interest of the victims. Because, Your Honors, in fact, I appreciate the fact that you have given us an opportunity to make an oral submission. But, Your Honors, this hastily prepared oral submission will in no way replace Mr. Ndretu's written submission, Your Honor. And there's a risk that Your Honors would arrive at a conclusion at these proceedings while not fully taking into account the written submission prepared by Mr. Ndretu. Your Honors, in the further, the victims will be disadvantaged at these proceedings because, Your Honors, I have to admit that from 1st until 6th of January of this year, the Citrix, the system, which the legal representative who is based in Kenya receives all the court documents, all the notifications. This system hadn't been operational during that period, Your Honor. And I wish that Mr. Ndretu were here today, and I'm only appearing on his behalf. But this also, you know, partially caused by the system of legal representation set up in this case, where OPCV acts on his behalf. And, Your Honor, Mr. Ndretu is one of the few Kenyan lawyers who are present in this room, along with Mr. Kenyans and some members of his team. And in his written submission, he had provided his in-depth analysis of the Kenyan constitutional law, Your Honor. And I can safely say that being a Kenyan lawyer, just like other Kenyan lawyers in this room, they are more knowledgeable about the Kenyan constitutional law than any of us, I might say. Your Honor, and in the totality of the circumstances, Your Honor, these exceptional circumstances would justify, Your Honors, a decision granting retrospectively an extension of time limit to Mr. Ndretu's written filing. And
all right, can you now make your submissions on the substance, beginning with the differences between your position or submissions and those of the prosecutor? Has anything extra that you say that the prosecutor didn't say either orally or in their written submission? We can begin with that. And then we see what happens about your request for retroactive extension of time.
Thank you, and I appreciate that. Your Honor, some of these things I'm going to say might appear duplicative, but in a way I'll try to avoid any duplication and go to the essence of the matter. Your Honor, victims, we believe that the rule in question, the Rule 134 Quater, is a rule, Your Honor. This was a let's say it was a conscious decision by the Assembly of the State Parties to introduce this rule as an amendment to the Rules on Procedure and Evidence, Your Honor. This fact itself speaks of their intention not to amend the statute, Your Honor. The fact is, the principle that the accused shall be present at trial is a principle of criminal law, principle of international criminal law, which hadn't been substantially changed. The Assembly of State Parties, they have a power to amend the statute instead of introducing this rule, but they have consciously and knowingly introduced amendment to this rule, Your Honor. Therefore, the rule is still remains. The rule still remains is that the accused shall be present at trial. But this rule specifies.
Mr. Naratsetse, you say that presence at trial is a principle of international criminal law. Mm-hmm. You do recall, don't you, that the ICTR, the Baragwiza case, was tried with Mr. Baragwiza entirely absent from the courtroom for the entirety of his trial. And the rules of procedure of the Special Court for Sierra Leone also indicates that an accused person may be tried while not there. So too does the statute of the Special Tribunal for Lebanon.
Your Honor, I have no practice law at those tribunals that you have mentioned, Your Honor, but I would rather stick to the text of these rules and procedures we have in front of us. Your Honor, the paragraph 1 says, which is administered to stresses this fact, that the accused who is subject to summons to appeal, who is mandated to fulfill extraordinary public duties at highest national level. As Mr. Stenberg has mentioned, the victims, we also believe that being deputy head of government, deputy president, such as Mr. Ruto's position, wouldn't qualify per se being, let's say, conducting public duties at highest national level, Your Honor. It's, in our view, it's for the defense teams, it's for the Mr. Ruto to justify the exceptionality of the circumstances that would prevent him being at trial continuously.
Mr. Again, stop to, sorry, I apologize for interrupting you, but the prosecutor had made that argument on your behalf. Why don't you move to another point?
Yes.
And we've got his argument in that regard.
The another point, Your Honor, Mr. Indra, to stress the fact that according to the Constitution of Kenya, especially under Article 147, paragraph 1 to 3, it says that deputy president shall be the principal assistant to the president and shall deputize for the president in execution of president's functions, Your Honor. In the victim's view, Your Honor, Mr. Indretu and I would like to stress the fact that in this case, the deputy president is only an assistant to the president. So according to the text of the Kenyan Constitution, we would argue that the words such as being principal assistant doesn't let's say these words mean that the deputy president do not ordinarily deputize or do not ordinarily replace the president, but only during the functions the president knowingly and voluntarily assigns certain functions, then the deputy president would be acting on the instruction of the president. So ordinarily,
what does that tell us? I mean, does it also mean that because the Kenyan Constitution uses the expression secretary to describe a functionary that in other places may be called a minister, so we are to limit ourselves to the ordinary understanding of the word secretary to be the same as the one who helps you in your office to do your work? Is that the same?
Your Honor, we
just
would
because
the
Constitution, just because the Constitution uses the word assistant, could it mean assistant in the generic senses, equivalent to deputy, vice? Does it help us?
Your Honor, as you have mentioned, the Vienna Convention on the law of the international law of the treaties gives us ways to interpret international treaties. And the Rome Statute and the Rules of Procedure Evidence, especially this Rule 134 Quater, says that those accused fulfilling their public duties at highest national level, Your Honor. Your Honor, according to the Vienna Convention, while interpreting international treaty, we should stress the plain and ordinary meaning of the words that legislators have agreed. And while interpreting these specific terms, we may also resort to national laws. In this case, the Constitution of Kenya, which in a way defines what the deputy president does and does not. But the fact is, the Constitution is clear when it says that the deputy president will only be a principal assistant. It doesn't say that the deputy president will fulfill all the functions as the president does. If I make any sense, Your Honor, I would move on. And victims, we would also like to stress the fact that these functions must be extraordinary in nature, Your Honor. If you honors might recall that when the Westgate Mall attack had happened, the victims, our position was that Mr. Ruto had he was justified in requesting that he would be excused from the continuous presence of trial. In that case, Your Honor, we supported the defense. We didn't oppose the defense request. So in that circumstances, Your Honor, we acknowledge the fact that in certain circumstances, the public officials, the highly placed, such as president or deputy president, may be called to fulfill an extraordinary duties, Your Honor. And in our written submission, Your Honor would see that Mr. Indretu stressed the fact that the defense failed to raise any exceptional circumstances where the request is based. And in that regard, the defense request is open-ended, and the defense request can be qualified as a blanket request for excusal, Your Honor. Blanket, meaning that Mr. Indretu and we believe that the blanket excusals are those excuses that do not find any factual, do not make any factual circumstance, do not make it into an argument where the extraordinary nature of the functions would be called to fulfill. Therefore, Your Honor, we believe that in conclusion, the Ruto defense request should be rejected. And my last point, Your Honor, that Mr. Han also referred to the fact that indeed the interest of the victims may be affected because of their request seeking Mr. Ruto's excusal. In that regard, Your Honor, we would like to stress that the Rule 134 Quater also states the fact that the granting of the excusal must be in the interest of justice, Your Honor. In our interpretation, the interest of justice, the notion of interest of justice includes the interest of the victims, Your Honor. And the interest of the victims in this case is that victims do wish to see Mr. Ruto at trial in the courtroom, Your Honor. We, of course, acknowledge that Mr. Ruto is presumed innocent, but until and unless he clears his name officially and formally at the end of these proceedings, he is still facing very, very serious charges, Your Honor. Therefore, victims, we do have an interest to see Mr. Ruto at trial and answer those charges that put forward by the prosecution. And, Your Honor, as you may also recall, the appeals chamber said that the subject matter of the hearing must be also taken into account. This is also what the text explicitly says. The subject matter of the hearing must be taken account. Therefore, Your Honor, you may also recall that in your initial decision granting Mr. Ruto's excusal, you have put certain conditions. And one of the conditions was that Mr. Ruto must be present at trial in the courtroom when the dual status witnesses and victims would come and testify and when they express their views and concerns, Your Honor. And we fully agree with that point. And we believe that especially in cases where the dual status witnesses are called to testify, we believe that no excusal can be granted. And therefore, defense request is a blanket request in the sense that defense request doesn't raise any arguments where the victims expect Mr. Ruto to be in the courtroom when they come and testify.
Now, so the argument then would be, your submission would be, that in those sorts of circumstances, the interest of victims should be considered as superior to the interest of the Kenyan state, whose sovereignty more or less is implicated by their vice president being now on trial. Is that your argument?
Your Honor, that is not my argument, Your Honor. If I gave you such impression, I would apologize. But the fact is, Your Honor.
I did not say that's your, I'm asking you, that's your argument.
Yeah. The fact is, Your Honor, victims, we would also like to stress the fact that the Assembly of State Parties introduced this rule in question in order to counter the practical issues that this and other trials might face, such as the Westgate Mall attack I had mentioned earlier. Therefore, Your Honours, we pray that Your Honours would keep appropriate and good balance between those competing interests. Victims' interests are, of course, very important, but at the same time, we do not argue that victims' interests would prevail all other interests or rights of the defense, and there must be good, delicate balance, and we pray that Your Honours would take into account the interests of the victims when considering the defense request. Thank you, Your Honours.
Thank you very much, Mr. Khan. Mr. Keegan-Katwa, I will not call on you to make submissions. I hope you don't mind that. I will be hearing you on something else.
Mr. President, I really wish you could give me a few minutes.
1 second. I would want to hear from Mr. Khan. 5 minutes. Only 5 minutes, Mr. Khan.
I'm grateful, Mr. President. I've listened with interest, Your Honour, and there's been some interesting submissions put forward. Can I start by saying, in our respectful submission, one should not be distracted by an assertion that the Rome Statute should be amended. And no persuasive reason has been put forward by anybody in this courtroom to state that the Rome Statute is deficient. Indeed, we say the beautiful thing about the Rome Statute is that it is well capable of holding the meaning and granting the relief that we seek. Your Honour, that was made clear, in fact, by the Appeals Chamber, because contrary to the prosecution's submissions which were rejected, the Appeals Chamber made clear that this court was correct in properly interpreting the word or the requirement shall be present in a balanced and proper manner, rather than mechanically importing into that word a mandatory straitjacket that would bind the court. And, Your Honour, for good reason. We've had examples in this case and in the Bemba case to show why judicial flexibility, why the proper interests of justice require such a construction. But, Your Honour, my learned friend for the prosecution put forward what I say is an unsupported, a novel position, that in the event that the Assembly of State Parties takes a view which departs from the Appeals Chamber, the only recourse available to it is to amend the statute. That's not a principle that finds support in international law or indeed the statute. Article 21 has been raised by the prosecution itself, and the very first paragraph talks in relation to sources of law, the statute, elements of offences, and the rules of procedure and evidence. It does not state the statute, the jurisprudence of the Appeals Chamber, elements of offences, and the rules of procedure and evidence. So even if, for the sake of argument, even if there was a dispute between the Appeals Chamber and the Assembly of State Parties, we say that it is for the Parliament, the legislature, to put out the law, and for the judges, all the judges who've been elected by the Assembly of State Parties and who've sworn to discharge their responsibilities, to apply the law. It's not in any system for the Parliament to follow what the judges say. It's the other way around, in very simple terms. But, Your Honours, we say that such a construction is not necessary because rather than this being a rivalry between the Appeals Chamber and the ASP, fighting for maestry, to use one of Chaucer's terms, fighting for the upper hand in the relationship, we say a proper and accurate understanding of what happened shows that the Rule 134 Quater can be interpreted in a manner that is consistent with the Appeals Chamber, because importantly, the Appeals, and this is a critical point, the Appeals Chamber did not for a moment depart, set aside, or overturn or make any findings regarding the functions of William Ruto as Deputy President. It was talking in general terms, and that finding of the Appeals Chamber has been endorsed, not rejected. It's been endorsed by the Assembly of State Parties in 134 ter. And this is, Your Honour, where perhaps I was not of assistance, we should not get hung up on blanket excusals as if they're prohibited. They're not prohibited. They're not prohibited. What the Appeals Chamber is stating is attendance, physical attendance, can be the norm. And any exception to that must be to the extent strictly required. So what is that? Now, for individuals like my friend Mr. Sang, he made submissions once to go to a graduation of his child. That's a 134 ter situation. But what the Assembly of State Parties has effectively said is the duties of a head of state and a deputy head of state, because they were looking at the situation of, in very clear terms, looking at context, that the Kenya situation had brought to the front, the situation of a president and a deputy president seeking to cooperate with the court and balance their constitutional responsibilities with their obligations to this court. What the ASP did is to find and to clarify that in circumstances where an individual occupies or has a mandate to discharge responsibilities of an extraordinary nature, effectively, excusal for that period, for the duration that individual holds that office, is strictly required. It is strictly required. And
so can we leave it there on the main argument? On your first argument, we will move to the second issue. Mr.
I'm grateful.
Katwa, I know you want to speak, but let's see if we can get you in on the second leg of the debate. Mr. Khan, can you now address your addendum?
Your Honour, the addendum issue is straightforward, and in fact it's linked to the substantive argument. The Deputy President does not play a cameo role under the Constitution of Kenya. He's not an appendage. He can't be fired by the President, unlike Cabinet Secretaries and the rest. The only two individuals in Kenya...
or his private assistant.
Indeed, or his secretary. The only two individuals in Kenya that have a democratic mandate by the people of Kenya in free and fair elections is the President and Deputy President. And, Your Honour, it would be churlish in our respectful submission to somehow dilute the responsibilities and the functions of that office simply because it may appear that it would give some succour to an argument that would require that individual's attendance before this court physically at all times, and I'm sure that's not going to be the case. Your Honour, those responsibilities are very clear. But, Your Honour, as has been made clear in the addendum and other filings, that part of Africa, that part of our world, has some unique problems at the moment. And the President at the moment, as we speak, is in Angola discussing, as we say in the addendum, very important issues. We know there are problems and difficulties and challenges in South Sudan. We know that there are difficulties in the Democratic Republic of, in the Central African Republic and elsewhere. And the more that the President is focusing on regional security, and of course national security depends upon that, the more functions are delegated, the greater the burden of responsibility that is on Mr. Ruto's shoulders to discharge. Your Honours, because the President at the moment is in Angola for this important meeting, including very important African leaders in the region, people like Mary Robertson is there, the United Nations and all the rest of it, the President cannot, the Deputy President is requesting to be excused at the very least until Monday. The first aspect of our prayer is that if possible, if the bench was so able, we would very much appreciate and be most grateful for an oral ruling today on the substantive motion, albeit that written reasons perhaps would follow. But if for any reason that the bench was not minded to give an oral decision on the substantive motion today, at the very least what we would humbly request is the most anxious consideration be given to our prayer that Mr. Ruto be excused at least until Monday, so the President can come back to Kenya from his efforts at assisting and facilitating regional peace and security, and that will allow, his return to Kenya will allow the Deputy to travel to the court. Your Honour, that's our request, and I think it's in those simple terms. I'm grateful.
Mr. Steinberg, you will speak to that, of course.
Your Honours, my understanding is that this request is made under Article 63(1) and not under Rule 134 Quater. My only observation is that it appears that my learned friend has not addressed all of the requisite elements set out by the Appeals Chamber. In particular, he's not addressed the possibility of alternative measures. He's not addressed the subject matter of the hearings, which in this case...
Why do you understand that it's not under 134 Quater? We now have 134 Quater that's been operative immediately, isn't it?
Well,
upon adoption by the ASP.
Sorry, I see perhaps I am misreading it, and I see my learned friend seems to be indicating that he did intend to bring it under 134 Quater. Well, in that case, I would...
I expressly state it in the body of the application. It's expressed in addendum, and the power is expressly stated as under 134 Quater.
Fair enough.
Then I misapprehended, and I apologize for that. But then I would add to my list, he's also failed to address the issue of interest of justice, which is raised by Rule 134 Quater. And indeed...
but he says it's about that it is regional security that relates to national security issues. Do those not...
That goes to the issue of whether or not it is extraordinary duties, etc. He's spoken as to the extraordinary duties of the President, and I understand that the argument would go that because the President's duties are extraordinary, therefore the presence of Mr. Ruto in Kenya to deputise for the President would also be extraordinary. Your Honours, the prosecution doesn't take a strong position on this other than to observe that it does not appear to the prosecution that my learned friend has properly motivated his request in this regard. We are gratified that it is extremely limited, so at least to the extent that it is limited to what is strictly required has been met. For the rest of the matters, noting what we say are the deficiencies in the application, we leave the matter in the hands of the court.
Just you're not necessarily opposing the application, is that it?
The court will bear with me for one moment, please. We leave it in the hands of the court. Your Honour, if I may, while I'm on my feet, just one matter I omitted to correct, and that was with respect to my learned friend's suggestion that the prosecution's argument under 21.3 was raised for the first time today. I would just draw your Lordship's attention to our appeal brief, that is filing number 831, where at paragraph 36 we do specifically refer to Article 23.1 and its interrelation with Article 27.
Mr. Narasat Singh.
Your Honour, we appreciate this chance to make our contribution, Your Honour. In our view, Your Honour, the proper course should have been that the Ruto defense, we believe that the Ruto should have filed this addendum as a separate request, but because it's filed as an addendum to the previous main request, we would have to treat these two requests together as one. Your Honour, in general, we would oppose, as I have made argument on it, we would oppose the main request, but with regards to the addendum and the issues raised in the addendum, we would still remain within the spirit of our written submission, Your Honor, and we would leave it to your hands. That's all. Yeah, thank you.
Thank you very much. Now, Mr. Kenyans Katwa, how much time do you think you need? Now, we want to try and take in the other matters left that indicated to the extent possible today, and we've got 30 minutes left.
Could I request, Mr. President, for approximately 7 minutes?
Please proceed.
Mr. President, the words of Rule 134 quarter use the words that the individual is entitled to seek excusal if he is mandated to fulfill extraordinary public duties at the highest national office. Your Honors, we submit that Mr. Ruto's request, both the principal request and the supplementary request, the addendum, rather, Mr. President and Your Honors, fulfill these criteria. Mr. President, the use of the word mandated must have contemplated the possibility that the person has been conferred those duties by people other than himself, that he has not conferred it upon himself, and that he is not seeking it for himself. The use of the word extraordinary, Your Honors, must have been intended to anticipate a situation where the service or the purpose that the individual is serving is at the highest, and those words are also used, at the highest national level. Mr. President, the appeal chamber itself used the words in its decision that the President and the Deputy President are the principal members of the national executive of the Kenyan Republic. The prosecution in the argument attempted to emphasize or to allege that there does exist a distinction between the office of the President and the office of the Deputy President. Now, that is an argument that was already presented both to this chamber and to the appeal chamber. And when the appeal chamber used the words that the President and the Deputy President are the principal members of the national executive of the Kenyan Republic, their intention can be read to be consistent with the words used in the Rule 134 quarter in saying the highest office. And Your Honors, I would submit that if the intention was to place the Deputy President below the level of the President in the intentions of the article and the rules, then the words that would have been used by the appeal chamber would have been that the President and the Deputy President are the principal and the Deputy Principal of the national executive. To the extent, therefore, that the appeal chamber identified the two of them as occupying the highest level of the executive, we submit the Article 134 is adequate criteria to use to grant excusal to Mr. Ruto. Arguments were made that the Kenyan Constitution makes the Deputy President that the functions of the Deputy President depends on whether or not the President has already assigned him any functions. Your Honors, it is acknowledged that Article 147, subsection 2 of the Kenyan Constitution says that the Deputy President will serve such functions and such assignments as the President may have given him. The arguments made by both.
Are you reading from a particular text you can read out? So we.
Yes,
the
Mr.
text
President.
of the constitutional
The
provision.
Kenyan Constitution,
yes,
yes.
that says that. We would like to hear the precise text.
Yes, Mr. President. The precise words used by Article 147, subsection 2 is that the Deputy President shall perform the functions conferred by this Constitution and any other functions that the president, any other functions of the president as the president may assign. And the two arguments I wish to make on that point, Your Honors, is, first of all, there is an acknowledgement that the office of the deputy president in itself has some functions. And that is why that subsection says that the deputy president shall perform the functions conferred by this constitution, meaning that there are some functions which have been conferred on the deputy president. The second part of that provision or that article is to the effect that any other functions of the president as the president may assign. So that there are two distinct roles that he serves. One is such roles has been assigned to him as the deputy, and the second set are such roles as the president may assign to him. And so, Your Honors, the arguments that there need to have been demonstrated that the president has specifically assigned some certain roles to the deputy president need to have been provided before that section can be enjoyed by Mr. Ruto. Is not supported by that subsection of the article, Mr. President and Your Honors.
Is there any distinction between the concept of performing the functions of the president that the president assigns as a notion versus performing any other function that the president assigns that may not necessarily be the functions of the president?
Mr. President and Your Honors, looking at the words used by Article 147(2), it must be acknowledged that there is that distinction, that there are such roles as the deputy president himself has to discharge by reason of being the deputy president.
No, that's not what I'm talking about now. So that is settled. You've indicated in the reading that the Constitution says duties assigned by the Constitution. And then the second limb also says something, and that is, if you can read that again.
Yes, Mr. President. Mr. President, the words used are that the deputy president shall perform the functions conferred by this Constitution, and that's not an issue. The second part of it is any other functions of the president as the president may assign. And the explanation, probably I'll come back to your question, Mr. President, is the explanation of that, according to my understanding, is that there are some functions which the president is supposed to discharge. However, from time to time, it may become necessary for him to ask his deputy to assist him in delivering those, in discharging those functions.
So those would also be constitutional functions of the president that the president assigns.
Yes, Mr. President.
To the deputy president.
Yes, that's our argument. And Mr. President, Mr. Khan has already argued that that side of the world has challenges as it is. Some of the challenges which have been acknowledged even in this court is the issue of the Westgate. If it were to be said that this chamber has to be satisfied at every instance that the president has delegated this or this other function to the deputy, it would be very difficult, Mr. President, because issues arise as matters of emergency. There is also no protocol that has been defined that the functions that the deputy president has to discharge have to be delegated to him in writing by the president. And so I would argue that the reasonable understanding that should be given to this subsection 2 of the article is that it is possible in their relationship that the president can delegate some of the functions to the deputy president, and even for the security reasons, it may not be known to third parties, including this court, and that it is good enough to acknowledge that, in fact, the president has that option constitutionally to delegate it to the deputy, and that the deputy is obligated to discharge those functions when they are delegated to him. Mr. President, I would also like to argue that when the victims and the prosecution argue that the excusal should be more in terms of the exception than the norm, then it means there was no purpose and no reason to have enacted 134 quota. And, Your Honors, when the words were used by the state parties that excusal is allowed where the individual applying is mandated to fulfill extraordinary public duties at the highest level, it must be understood, Your Honors, in my submissions, as being a certain state of things. It is a static situation, so that the moment it is satisfied that the office of such individual is, number one, at the highest level, number two, is extraordinary, and number three, is founded on a mandate given to them. The moment all those three criteria are satisfied, I submit, Your Honors, then the excusal should be allowed, and should not be allowed from moment to moment. The intention of Article 134 quota in my submissions was not to contemplate an event. It is a static state of situation. And therefore I submit, Your Honors, that if it were to be said that the Deputy President should not be excused, then it requires, first of all, to be determined in your decision coming to that conclusion that, number one, his office is not mandated, number two, his functions are not extraordinary, and number three, that his office is not the highest office. However, if you come to the conclusion that all the three criteria exist, and if you come to the conclusion that he has a certain term of office as defined in the Kenyan Constitution and as must have been contemplated by the ASP, then we submit that the excusal should be the norm, the excusal from attendance, and the attendance, the exception, subject to the criteria that has already been defined in the 134 quota subsection 2, being the instances in the trial. Mr. President and Your Honors, we submit that the only other two criteria that you need to satisfy yourselves to give Mr. Ruto the excusal is, number one, whether he has given you the necessary waiver that he will not complain if the proceedings are conducted in his absence. And lastly, that he himself, both in his previous conduct and in any other prescription you give him, he will submit himself to the control of this court. If it is satisfied that Mr. Ruto has complied with all your conditions previously and complies with whatever conditions you give in future, then we submit, Mr. President and Your Honors, that it is only fair that you afford him the excusal and give meaning to the intentions of the 134 quota. Mr. President and Your Honors, thank you very much. Those are our submissions. Mr. President, could I say one last thing? Mr. Sang has been extensively referred to in these proceedings, both in terms of whether he is being discriminated and in terms of whether he is prejudiced by the excusal of Mr. Ruto. Mr. Sang, both as the co-accused of Mr. Ruto and also as a Kenyan citizen, wants to be clear unequivocally that he has no problem with Mr. Ruto being excused as his co-accused, and is happy to have Mr. Ruto excused to discharge the mandate of the Deputy President that amongst the 40 million Kenyans he gave to Mr. Ruto. Thank you, Mr. President and Your Honors.
Thank you very much. will issue an oral ruling. Defense counsel for Mr. Ruto had presented a request to the chamber dated the 16th of December 2013, and by a subsequent filing of the 14th of January 2014, they added further request modifying the earlier one. The purpose of both filings is to request the excusal of Mr. Ruto from continuous presence at trial pursuant to the new rule adopted by the Assembly of States Parties, Rule 134 Quarter. The prosecution and the victims' counsel oppose the main request as insufficiently motivated. The prosecution and victims' counsel take no issue as to the addendum request. Counsel for Mr. Sang did not file a written submission, but in his oral submission supported the request by the Ruto defense and made it clear that Mr. Sang does not consider that he is being discriminated against if the request was granted to Mr. Ruto. The chamber has considered the request. The chamber hereby conditionally excuses Mr. Ruto from continuous presence at trial on the following conditions. As indicated in the new Rule 134, including quarter, a waiver must be filed. That's one condition. The further conditions are these. Mr. Ruto must be physically present in the courtroom for the following hearings. 1. The entirety of the closing statements of all parties and participants in the case. 2. When victims present their views and concerns in person. 3. The entirety of the delivery of the judgment in the case. 4. The entirety of the sentencing hearing, if applicable. 5. The entirety of the sentencing, if applicable. 6. The entirety of the victim impact hearings, if applicable. 7. The entirety of the reparation hearings, if applicable. 7. The first 5 days of hearing starting after a judicial recess as set out in Regulation 19 bis of the regulations of the court, and 9, any other attendance directed by the chamber either proprio motu or at the request of a party or participant as decided by the chamber. The chamber considers that the attendance of Mr. Ruto pursuant to the requirement indicated in condition number 8, being attendance at first 5 days of hearing starting after a judicial recess, will require him to be present for today's hearing and the next, starting tomorrow and the next 5 days. However, in view of the need for Mr. Ruto to deputize for the President of the Republic of Kenya during his absence from the country from the 16th of January 2014, Mr. Ruto is excused from presence at trial on the 16th and the 17th of January 2014. Mr. Ruto shall, however, be present for the remainder of the period indicated under condition number 8. The fuller reasons for the oral decision will be issued in due course. That is the oral ruling on the requests. We have 5 minutes left on the clock for the scheduled hearing today. We will be adjourning now. We know we have other matters to take up. We will reconvene tomorrow morning at 9:30.
Mr. President, Your Honours, can I just check then? The court's ruling is that Monday, Tuesday, Wednesday of next week, Mr. Ruto is required to be present. Is that right?
Would be the case if that comes to 5 days. Is it?
2 days excused and then 3 days of next week.
That's correct.
I'm most grateful. Thank you.
The proceedings will be adjourned now.
All rise. Vive la paix.